Ghislaine Maxwell is back in the news. We've spent a lot of time talking about Ghislaine Maxwell because she has one of the most interesting cases that we've seen, at least from a criminal defense perspective, in my opinion. She's got a handful of lawyers. They are filing documents left and right. Every day it's just sort of this cascade of legal arguments that are being made from every direction. And it's actually very impressive, right? I've done a lot of criminal law. I've seen a lot of cases. We've talked about a lot of different cases on this channel even. And the scope, the volume of materials that I've seen in Ghislaine's case are just a sight to be seen. There really is something there. So I want to show you what's happening here. The Independent came out. They're giving us an update. They say dozens of documents about Ghislaine Maxwell's personal affairs will be made public, according to a judge. A judge ruled that last week. We saw on July 1st, this new order came out from Judge Allison Nathan. This is out of the U.S. District Court for the Southern District of New York. And a couple things I just want to point out. We're talking about unsealing of documents, okay? Here, in this case, Ghislaine Maxwell, Jeffrey Epstein, we've got decades of, sex trafficking allegations and sexual activity involving children and minors and all sorts of horrendous allegations. And this case has been really, working its way through our system for a long time. We've had many different people with their hands in the cookie jar trying to prosecute it and not prosecute it. We remember that Jeffrey Epstein, was prosecuted and he kind of got a slap on the wrist at one point in time. And then now they got him again. And then, of course, he didn't kill himself, but he's not with us anymore. And then they went and they found Ghislaine Maxwell. And so now they're sort of, picking up where they left off with Jeffrey Epstein, and they're just, running with it in Maxwell's case. And so a lot of this stuff has been very, very volatile. We've had a lot of different efforts to seal the documents to make sure that nobody could ever see them. Because as we all know, most documents in the court of law are public record. We can just go online and get them. But in Maxwell's case, there have been tons of documents. And we have talked about this previously. The number was something like 2.7 million pages of documents in this case. And when Ma Fox was here several months ago, he was telling us that if you actually sort of stack that up, it'd be something like, 900 feet or meters or whatever the calculation was. It would be like a skyscraper in terms of documents. So how could any defendant go through all of those things? It's sort of a due process violation in and of itself. And so we've all been wondering, where are the documents? Where are these 2.7 million documents? What's going on here? What was Epstein really involved in? What was Maxwell involved in? Which one of our elected officials was also sort of in on the scheme? And now we're hoping for some answers because the judge came out and unsealed some things. What did she unseal? Well, right here we have what's called a motion to suppress evidence. And so that was filed previously on June 25th. And the court came out and said, since nobody has any redactions to that motion, we're going to unseal it. A motion to suppress evidence is kind of exactly what it sounds like. It says, hey, we've got some evidence here that we think is tainted, and we're going to try to get that thrown out in court. So a good example would be in a DUI case, trying to get, let's say, for example, the blood results thrown out in the DUI case. So if somebody's being charged with a DUI, one of the most damning pieces of evidence is, of course, the blood results. And typically what happens is they'll draw 2 vials of your blood. That will get wrapped up. They'll impound it. They'll transport that down into an evidence locker. It will sit there until the forensic scientists pull it out and then do their analysis on it. And so what we're talking about is if you're able to now throw out a certain piece of evidence, in this case, it might be the blood results. Maybe they're tainted. Maybe the person, the analyst, the person who is pipetting the blood out screwed something up. And that is now no longer valid evidence. So if you're trying to suppress that, that means it doesn't come into court. It never actually makes it into the court of law, and it can't be used as evidence against the defendant. Very common type of case, but of motion, but it's also something that is not usually sealed. So in this case, the question is, why is this sealed? Why was this sealed in the first place? Well, it says now that there are no redactions being made, so nobody cares if it's unsealed. So the judge unsealed it, okay? And it's now available. She also unsealed an April 9th memorandum decision about a protective order in a different case, in the Guffrey versus Maxwell case. And we've also got some transcripts that came out of an ex parte hearing that also happened in 2019. And so we've got exhibits D, E, F, and G here. And so the court came out, Judge Allison Nathan said, everybody file your documents by July 2nd. And so many lawyers, many defense attorneys like myself, were all going, oh my goodness, is it Christmas in July? Are we going to get this treasure trove of documents? Is there going to be some juicy, spicy meatballs in here? No, there wasn't. There wasn't anything any good. Here is what we've got. This is a screenshot from the exhibits that came out here from the ex parte hearing. You can see we've got Exhibit D, E, F, and G, and there's just not much there. Remember what I was telling you, that there was something like 2.7 million pages of documents that are being transferred around, thrown all over the place. And now what we've got are 50-something pages of documents here. Exhibits D, E, F, and G. And when you look through them, they're not even that interesting. They're just sort of documents that say it's just a transcript of an ex parte hearing. Not that interesting. There are some interesting things that did come out, though, after the fact. So the day after this happened, and the day after the judge made this order, remember what happened. Bill Clinton is out of custody. He got released from prison because there was a non-prosecution agreement that allegedly, or the Supreme Court found, was in fact violated. And so I want to show you this. This is what's happening in Maxwell's case. We've got Maxwell now. You can see here in the case of United States versus Maxwell, this was filed on July 2nd, just a couple days ago, sent off by Cohen and Gressler. These are one of Maxwell's many lawyers. Send this letter over to the Honorable Allison Nathan. They say, "Dear Judge Nathan, we're sending you this letter because we want to call your attention to this recent case that came out of the Pennsylvania Supreme Court." They're talking about the Bill Cosby case. They say the court got rid of Cosby's conviction and sentence. Why? Because the district attorney's office that prosecuted him didn't live up to a non-prosecution agreement. And they're saying Maxwell's case presents a very similar situation. Accordingly, what they want is the court to dismiss several counts. Counts 1, 3, 5, 6, and of the S2 supervening indictment for violation of the NPA. The NPA is a non-prosecution agreement. So I want to frame this out briefly. Well, it's in the letter. Let's take a look at this. So they're going to explain to us what's happening in Cosby. Okay, so here's what Maxwell's doing. She's saying, listen, you know, he got a cookie, Mom, and I didn't get a cookie, so I want a cookie as well. And here's why I should get one. Cosby got a cookie, and that's a good deal, and you know he deserved it, and also I deserve a cookie, so can I have a cookie as well? And what they're going to do here in this letter is give us a little bit of background. They're going to explain what's going on, and let's run through it quickly, and then we'll break down what's happening here. So in the Cosby case, why is Cosby out of custody? Well, there was a woman named Andrea Constand. So she said that Cosby assaulted her sexually in January 2004. Okay. She did not immediately report that to the law enforcement authorities. Then in January 2005, so about a year later, 1 year, she then reported it to the police. Montgomery County Attorney's Office, so the prosecutor then, his name was Bruce Castor, he determined that he can't bring charges against Cosby. We're not going to be able to do it. He says there's insufficient, credible, and admissible evidence. He says you waited a year. He said among the factors that justified him not bringing the charges, he said she waited a year to file her complaint. It diminished the reliability of her claim and her recollections. Also, her statements about the event themselves were inconsistent. There was a lack of corroborating evidence, and she continued to speak and meet with Mr. Cosby even after the assault. And number 5, she had contacted civil attorneys to pursue financial compensation through a lawsuit against Mr. Cosby. So, you know, this woman goes, she says, I'm going to sue Bill Cosby. She goes and says, I'm going to file a criminal charge against Bill Cosby because I was sexually assaulted in 2004. It's now a year later. She goes to the prosecutor. The prosecutor, Bruce Castor, comes back and says, hey, we can't make our case here. It was a year ago. We don't have any sexual evidence. We haven't done a sexual examination. We have no real evidence. So here's what we can do instead. How about we just file or allow you to recover in the civil lawsuit? We can't win this criminally. There are a couple of reasons why. You waited too long. Your recollections are bad. You're not reliable. Some of your statements are inconsistent. And even after you claimed this happened in January, you still hung out with Bill Cosby anyways. So in other words, you're not a credible witness. A jury is not going to believe you. So now what can you do? Well, we know that you already filed a lawsuit against Bill Cosby. So maybe we can use that route to get you some recovery. So let's take a look here. DA Castor issued a signed public statement declining to prosecute Mr. Cosby. Which he never viewed as Cosby's lawyers understood to be an agreement that Mr. Cosby would never be prosecuted for the events involving Miss Constand. Okay, so there's a public statement here from the prosecutor back in 2000, whenever this was, 2005, saying that we are not going to prosecute Bill Cosby. Okay. He said okay, so Cosby says, if you're not going to prosecute me, great. It's a signed document. It's out there in the public. That means that I can go out there now and speak without having to be fearful of self-incrimination. I know you're not going to prosecute me for this incident with Miss Constand, and so now I'm willing to talk about it. But only on the basis that you're not actually going to prosecute me, right? You're not going to sort of be allowed to hang that over my head and then get me to go speak openly and then sort of bring those charges back from Cosby's position. So what Cosby says is, believing that he no longer had a basis to assert his Fifth Amendment rights, Mr. Cosby testified at several depositions in a civil suit brought against him by Miss Constand. And during that deposition, he made some admissions, right? He made some say things like, yeah, I actually, gave women quaaludes in order to sleep with them, which is totally illegal, right? If you're going to be drugging women to have sex with them, that is a crime. Now, what he did, of course, is he made those admissions after there was already a conversation that had taken place that he would not be prosecuted in that case at that time. 10 years later then, the successor district attorney, we have Risa Vetra Furman, used those admissions during the deposition to charge Mr. Cosby with the same crimes related to the sexual assault of Mr. Constand. Cosby then was convicted of those charges at trial. So they used his statements in that deposition against him. They said they weren't going to do it. They did it anyways. They had one prosecutor come back 10 years later, charge him anyways. The Pennsylvania Supreme Court came out and they said that the first attorney's promise was enforceable. The district attorney was not, the new district attorney 10 years later was not allowed to bring charges against him again. It was violating his due process rights. So as a result, the court vacated Cosby's conviction, right? So Cosby goes free now because the original prosecutor made a promise. And then Cosby gave consideration for that promise. There was an exchange there. Prosecutor said, listen, we can't get you criminally. We know that she's brought a lawsuit against you civilly. Money is another alternative. Rather than putting you in prison, maybe it's just about compensation, or maybe the victim in this case will be happy with just compensation. And we're going to let that civil case move forward. So the non-prosecution agreement then would have prohibited a second prosecution. And Cosby agreed with the non-prosecution. He actually went out there and testified. He, in good faith, went out there and said, hey, this is my story. Then they charged him again. Totally inappropriate. The court came out and said, not allowed. Conviction overturned. You're free now. So Maxwell's attorneys then come back out and they say the same principle that got Cosby free applies to Miss Maxwell. As in Cosby, the government is trying to renege on its agreement. And they want to prosecute Miss Maxwell over 25 years later for the same exact offenses for which she was granted immunity in the non-prosecution agreement. Indeed, the principle applies even more strongly in Maxwell's case because the NPA was a formal written agreement as opposed to an informal one like the one in Cosby. This is not consistent with principles of fundamental fairness. So accordingly, they want counts 1, 3, 5, 6 of the supervening indictment to be dismissed. This is signed off on by attorney Christian Everdell over from Cohen and Gressler out of New York on 3rd Avenue. So it's an interesting argument, okay? And now we have to think about this sort of in a couple different layers. So here in Cosby's case, right, this was a state court claim, came out of Pennsylvania. It worked its way up through the Pennsylvania state court. In Arizona, we call these superior courts. And in Pennsylvania, it was through a trial court, through a court of appeals. It went all the way up to the Supreme Court there. And the Supreme Court came out and said, nope, not allowable. Conviction is overturned. So that's in state court. Now, remember, Ghislaine Maxwell is not in state court. She's in the Southern District of New York, which is a federal court. And so it's an entirely different jurisdiction. So now what sort of Maxwell's attorneys have to do is show that the Pennsylvania Supreme Court is compelling enough, it's persuasive enough. The arguments that were in that case are persuasive enough to carry over into the federal framework. Just because it's two different systems. So just because Cosby got out doesn't necessarily mean that Maxwell's going to get out, right? It's an entirely different situation. But the argument nonetheless is still good. And candidly, right, I don't know the specifics here. I'm going to be very curious to see what the prosecutors say, because the prosecutors are going to respond to this and they're going to tell us that no, right, Cosby is distinguishable. Maxwell should not be released based on the non-prosecution agreement. But if you're just thinking about this from sort of a fundamental fairness perspective, if you entered into an agreement, if you signed a document that says you're not going to prosecute me, and then somebody else turns around and prosecutes you for that, that's a problem, right? That's a violation of all sorts of due process rights, because they are making agreements. You are giving consideration for that. You're exchanging something of value. In this case, Cosby was actually exchanging information about what happened so that he could sort of expose himself to liability. Bad framing there. Cosby opened himself up to liability civilly, right? And now Maxwell's attorneys are making the argument that that same principle should apply in her case. All right, so Cosby now, we have another one of Maxwell's attorneys. So here's Maxwell's attorney. His name is David Markus, and he wrote this letter or this op-ed or this opinion piece in the New York Daily News. He says, Bill Cosby is free. Ghislaine Maxwell should be too. He posted this June 30th, and he says the Pennsylvania Supreme Court did the right thing when it threw out Bill Cosby's conviction. He says prosecutors cheated. They promised Cosby that they would not prosecute him if he would testify in civil cases against him. Based on that promise, Cosby testified. He did not invoke his Fifth Amendment right to remain silent. Prosecutors then broke their promise and used Cosby's statements in those depositions to win a conviction against him. This is Maxwell's attorney on her current case. Okay, and so you say, wow, so he's out there sort of like, advocating on behalf of this, right? Sort of the court of public opinion now. He's out there saying Cosby's free, same underlying legal principle, same concept, fundamental fairness mandates that Maxwell also be released. Well, he published this in the Daily News, and the government was not so happy about this. In fact, they fired a letter right off back to the court, and they say, Judge, he's breaking the rules. This is what the document looks like. It says, Dear Judge Nathan, the government respectfully submits this letter to bring to the court's attention an opinion called the op-ed that was published yesterday in the New York Daily News. It was authored by David Markus, Esquire, who is, of course, Maxwell's attorney. He represents her in connection with this case. Mr. Marcus's statements in the op-ed were in violation of Local Rule 23.1, they say, which contains provisions relating to extrajudicial public statements by attorneys. Accordingly, for the reasons stated below, the government respectfully requests that the court order Mr. Markus to comply with the rules. So it's just what prosecutors do. They say, you're violating the rules, right? Hey, how about the argument? Are they going to respond to the argument? Well, certainly, I would imagine that they will soon, but we haven't seen it, right? So Markus comes out and he says, hey, what they did to Cosby was wrong. They did the same thing to Maxwell, so she should also be released. He writes a letter, fires that off to the New York Daily News, and the government says, you just violated Local Rule 23.1 there, buddy boy, and they're going to ask the court to make sure that doesn't happen again. So that's what's happening in the Ghislaine Maxwell case, and we're going to have continued updates there, so hopefully you stick around and subscribe for that. Now, Miss Maxwell is, of course, she's got a whole slew of attorneys. Most people don't need about 20 lawyers like she has, but some people do need a good team. And of course, that's what we are. Over at the R&R Law Group, we've got an amazing team of attorneys and people who really help good people facing criminal charges find safety, clarity, and hope in their cases and beyond that in their lives. We offer free consultations. Our phone number is 480-787-0394. You can find us online at rrlawaz.com. And if you want, you can take a picture with this QR code. It will take you right on over to our website where we are ready and available to help. We love to help good people. We have a whole team of amazing people that are good at what we do, and we really love the work that we do. If you are not in need of legal services, that's a good thing. I want to invite you, though, to take a look at my Gumroad account over here. It's gumroad.com/Robert Gruler. I've got some good offerings there. Law enforcement interaction training, which is a 2.5-hour course where we learn all about the 1, 2, 3 rule for dealing with law enforcement, just to make sure that you protect yourself in the event that you're dealing with law enforcement. All right, so let's take a look at some questions coming in over from watchingthewatchers.locals.com. Let's see who is up in the house. We've got Jeremy says, deal or not, how did they convince his lawyers to allow him to confess? From a defense standpoint, I would guess you would never admit anything no matter what. So I think that would be Cosby's case, right? So in Cosby's case, they're talking specific, there was an agreement. And it wasn't as formalized as I would have been comfortable with, but it was still something that was sort of known. And the charges truly didn't come until about 10 years later, right, when we had the new county attorney come into place. And so it's kind of it worked out for him, right? Because the fact that he did testify means that he got out of prison early. Now, in my opinion, right, he should have never been prosecuted in the first place. What those prosecutors did was make a deal with him that they violated, and I think that that is unethical. All right, let's see what else we've got. We've got Three Girlies is here. Says, I heard some commentary that Weinstein would try the same thing. The idea was that Cosby got out of jail, so Weinstein would try to get off the same way. Turns out it is Maxwell. Yeah, you're probably going to see it from Weinstein too, but I don't know if he had the same agreement. If you are being charged with a sexual assault case and you have in your history any sort of non-prosecutorial agreement, non-prosecution agreement, then yes, you should be referencing the Cosby case all day. Now, but typically you would imagine, right, these are long, sort of higher profile cases like we see with Cosby or Maxwell, where you might have a long history of sort of these high profile cases that might involve some non-prosecution agreements, right? Not everybody who is charged with sexual assault is in something that is that meaty, like Cosby was, of course. Now, Darbs here. Darbs says he never truly recovered after they took Little Bill off the air. We have, I don't know what that was. Is that a cartoon? We have the Boxing Cat says, Ma Maxwell must identify as a Republican. It's a two-tier justice system. We have Three Girlies says, I miss the old Bill Cosby when he liked pudding pops and drew a little squiggly lines. He was a good sitcom dad. He went down fast. Yeah. We've got Nadarb says, something tells me the severity of their crimes are a tad bit different. Want to know says, would it matter if these were state and federal prosecutors? One makes promises, one uses evidence against you, like a civil rights violation. It's a great question. Want to know. And yeah, you've got two different jurisdictions and you've got two different, types of charges. And what you can see happen is exactly what we see with Chauvin, right? Chauvin was charged locally in state court, in the court of Minneapolis, and that ultimately needed to be dealt with. But we saw that there were some conversations about a global plea deal also involving the federal civil rights charges. So, sometimes they'll want to wrap those things up into one. We recall in the Chauvin case that there was some conversations taking place around the plea deal, and William Barr, Trump's attorney general, put the nix on that. Didn't allow that to happen, largely because I think that the deal that he was envisioning was a little bit too soft, and it didn't wrap everything up into one. I think it was just a 10-year deal, which would have been short given the fact that Chauvin got 22 and a half years, of course. Let's see what else we've got. We've got Thunder in here. Says Thunder 9 says the SDNY are like a mafia with rules they make up to suit their left-wing Democratic allies. They gave Epstein a slap on the wrist decades ago for having sex with minors, but spent 4 years trying to convict Donald Trump. We've got, let's see what else we've got. We've got Joe Snow's talking. We've got some chats going on. We've got, let's see, Bill Cosby here says when he used to be a normal human, then he became an even creepier human. Yeah, look, I'm not dismissing anything that Bill Cosby did, right? I'm not at all. But due process is due process. And if you've got a prosecutor who's making an agreement and then violating that, that's not appropriate at all. So, he can be somebody who did a lot of, awful things, but he still deserves the presumption of innocence. We still don't want the government to railroad anybody, no matter what the severity of the crimes are. Because what happens is I always talk about the pendulum, but it swings both ways, right? We have a situation where it may be good to dogpile on somebody. It doesn't matter who it is. It could be Jeffrey Epstein. It could be, Derek Chauvin. It could be Bill Cosby. It could be Harvey Weinstein. It could be the insurrectionists, the MAGA protesters, right? Anytime that there's this massive dogpile, sometimes it feels good and everybody just says, oh, that's great, right? Those people are useless. We don't even need to have a trial because we all saw what happened and we know how this works. And no, right? That's when we need the presumption of innocence the most. That's when we need due process the most. That's when defense attorneys should be sort of tumbling all over themselves to represent that person, because that's the hard line, right? Everybody can have an easier time representing somebody for that's a good defendant, right? Oh, she's a grandma. Oh, she's a college student. Oh, this person is a amazing individual. That's fine, right? Everybody go, okay, well, we can work with this person and we can go and negotiate and we'll tell them about all the good things that you're doing with your life. Right? Those are ideal candidates. The most heinous crimes, those are the ones that everybody runs away from, and that's when you need a defense the most. Good questions. Let's see what else. Let's take a look. A couple quick other ones. No Doubt is here. Says, I didn't get the impression that the Supreme Court decision was narrow. Why would it make a difference of whether the agreement was between federal or state court. It was narrow. So yes, so in the Cosby case, I think that you're right. It wouldn't, right? It would be the same. Well, I don't know I don't know on that one, right? I'd have to sort of look into the case law on it, but I think your point, no doubt, is essentially that if Cosby goes and testifies during the deposition in the civil case, that should immunize him from any criminality coming from the law enforcement system, regardless, whether it comes from the state court or from the federal jurisdiction, from the U.S. Attorney's Office or from the state prosecutors. It should insulate him. And probably what happened, it was just a jurisdictional conversation, right? We have a situation where there's a sexual assault allegation that is a state crime. Federal jurisdiction, typically wouldn't find a way to work itself into that case. So as long as in that situation there was a pretty clear understanding that there was not going to be a prosecution there, I don't think that Bill Cosby would have to worry about federal charges coming down the pike for him. Now, that's different than Ghislaine Maxwell's case. Okay, Ghislaine Maxwell, because her charges did not originate as a state charge. Hers involved all sorts of international stuff, right? The allegations were that these people were being trafficked internationally and to the Epstein Island and so on and so forth. So the feds got her case right away. And, I guess which I think that was the case though anyways. I think with her prior plea agreement, the non-prosecution agreement, which happened previously with Epstein. Remember in Epstein's case, they said that any one of Epstein's accomplices also could not be prosecuted. It was sort of one of the most sweetheart deals that anybody could have ever gotten. And so I think that would have applied to everything. And so that's what Maxwell's attorneys are arguing. I think it makes good sense. Let's see if we've got some other ones. We've got Maxwell complaining about being locked up. We've got the Darbs says we've got some madness in the house. All right, good questions, everybody. Thank you for all your support over at watchingthewatchers.locals.com. And we've got one more segment to get through today before we wrap up and get on out of here. But we got one more question. Let's do this. See the Veil says, we don't know the full discussion between that prosecutor and Bill Cosby with the NPA deal. They could have been threatening him with the constant haunting of a crime he didn't commit, and thus just confess it all goes away. Because he did the confession, then everyone assumes it's true. How do we know if he was innocent versus the prosecutors harassing him into a confession? Hollywood is plagued with all kinds of false allegations, and then the real crimes never get prosecuted. So let's see. Innocent versus... Yeah, it's a good question there, See the Veil. They could have been threatening him with constant haunting of a crime he didn't commit. So I think what Cosby's strategy there was, of course, is just to go talk during the civil deposition, settle the case, right? Pay her money. He's got gobs of it, and settle everything out that way. The prosecutors picked it up 10 years later, and they decided to charge him regardless. And so you can't do that. Because here's why. If they would have told him that we're going to continue to prosecute you, he never would have given the deposition. His attorneys would have said, "You're not talking. Are you out of your mind? You're not going to say anything." So it was consideration. It was actually, there was some exchange that took place there. All right. So those are all great questions, all coming over from watchingthewatchers.locals.com. All right.